Next, we will go with Mr. Morin. Mr. Morin, I believe the floor is yours. Correct me if I'm wrong.
No, Ms. Stubbs is to go first.
Cede your time to Ms. Stubbs. So Ms. Stubbs, the floor is yours. You have 5 minutes, please.
Thank you, Chair. I appreciate that. I do just want to mention, Minister Freeland, of course, we Conservatives, because we've been calling for fast-tracking clarity and certainty on all of these pieces of legislation and regulations that C-5 allows to be circumvented, we would agree with your comments here today that there is a thicket of legislation and regulations that means big projects can't be built. But that is why we as Conservatives are saying those are your fundamentals to fix those laws instead of doing this workaround. But I just, and further to the point that one of my colleagues was making earlier, Canadians have yet to hear from any of you how it is that you are going to enforce federal jurisdiction on interprovincial pipelines, which are federal jurisdiction, which of course you've failed to do before. But as a person who comes from Treaty 6 and is proud to represent and work with 5 First Nations and 4 Métis settlements in my area, all of whom are involved in both traditional and clean energy, and who are the service suppliers and contractors to the oil sands, and also as a descendant of the Broken Head Ojibwe First Nation from Manitoba, I too am concerned about this government's ability to fulfill its duty to consult so far through this legislation. What's concerning, Minister, is you talked about 3 different levels and layers of approval, which is obviously uncertain in itself. And I'm glad to hear that C-5 is promising capacity funding for the meaningful participation of Indigenous communities through this process. I would note that was also promised through C-69. And every time I ask the Indigenous leaders and workers and proponents and private sector owners and operators who, as you know, in Alberta for decades upon decades have been earning their own source revenue for energy development, they say none of that funding ever flowed. So I sure hope that you guys will keep your word this time. But I think that it really is incumbent upon you to clarify exactly how that duty to consult will be deployed by the actual decision makers, since the court are clear that's what required is the two-way dynamic to address the to mitigate adverse impacts on affected communities. And I particularly ask you this question in the context of yesterday's AFN National Chief saying C-5 will be an open invitation to court challenges and go all the way to the Supreme Court. So for all of us who want to get to yes in a good way, how will you actually make clear to Canadians that for the first time you will actually fulfill the duty to consult fully and completely, and make that be able to happen given the differences in views among the 600 plus Indigenous communities in Canada?
Thank you, and thank you for the question. So one of the challenges is having a single definition for Indigenous consultation, because like you mentioned, there's 600 different First Nations, there's Inuit, there's Métis, and so we want to make sure it's meaningful and adequate, and so having that single definition doesn't work. It's also important, it's very fact and situation specific. So for the projects contemplated under this bill, it would depend on the nature of the project, which Section 35 rights holders may be impacted and to what degree, the nature of the Section 35 rights that may be adversely affected, and there's a number of other variables.
Thank you, Minister.
And these ones are affirmed by the Constitution.
Yes.
We've got the Supreme Court. And then this legislation in particular references in the preamble, Section 5.7, Section 7.2, Section 8.3. Those are all required to have to consult with Section 35 rights holders.
Right, and Minister, which has not been done to date, we learned yesterday, but also the bill does set up the cabinet ministers as the decision makers. So will cabinet ministers be at the table on those projects as you go through this specific project by project ad hoc, obviously inherent uncertain consultation? And also, Minister, you yourself mentioned the removal of projects from the national interest list, which you can imagine is deeply concerning, certainly also to Indigenous proponents of, for example, pipelines that got vetoed in the past that they were relying on, or LNG projects that got killed in the past that they were relying on, and had spent years negotiating with big companies in a good way to get benefits for their communities. How can Canadians and Indigenous people who all want to get to yes in a good way on these big projects trust the claims here?
Yeah, thank you. So for that one, that's section 8.3, so page 12 of the legislation. So if a project is going to be removed, again, there's the requirement, the consultation, and the duty to consult with Indigenous rights holders who may be impacted. So,
But then
Thank
you
you
can
very much,
imagine a
Ms.
project
Stubbs.
proponent
Thank you,
getting all
Ms.
the way
Stubbs.
through and then being told no. And also, then why don't we just start with all the Indigenous
Thank you,
projects
Ms.
in front of the
Stubbs.
regulators right now and fast track them?
And thank you very much, Minister.
Thank you, Chair. And I just want to congratulate the Minister on her appointment to Mr. Alty. Many First Nations often rights get kind of it's hard to understand for First Nations when it comes to Section 35, treaty rights, the umbrellas under that when it comes to how provinces have jurisdictions in certain areas. First Nations traditional inherent rights are mixed into Canadian law. Treaty First Nations have long held that Natural Resource Transfer Act violates treaty rights, particularly Treaties 1 to 11. I'm wondering if the Minister agrees with First Nations rights holders in this regard.
I'd have to look into that further.
Does the Minister agree that resource revenue sharing, when it comes to major projects and natural resource extraction, is a model to agree with that model of resource revenue sharing from the federal government?
I know in the Northwest Territories that's an element, but I'd have to look into it further. As you mentioned, new to the portfolio, so look forward to discussing with you further.
The government has cited $40 million in consultation engagement for First Nations. Typically, we've seen a lot of spending on third-party consultants, $20 billion plus in consultants from the Liberals planning to spend $1,400 per family. For this particular instance, can the Minister guarantee that the $40 million will go directly to rights holders, Indigenous communities, rather than third-party consultants?
Thanks for the question. So it is for Indigenous rights holders. I know in my jurisdiction that, or in my territory, that some rights holders then go to hire consultants, and I wouldn't be in the position to say rights holders have to hire somebody full-time on their team. If they are going to hire a consultant to lead their work, that would be up to the rights holder.
Thank you, Chair. I'd like to pass the rest of the time to the member, Jamie Schmel.
Thank you.
Thank you very much, Chair, and thank you to my colleague, Billy Morin, for the time, and congratulations, Minister, on your appointment. Look forward to working with you. Minister, we've had a number of nations here in the capital raising awareness of the fact that they were not consulted on Bill C-5. In particular, the Anishinaabe Nation First Nations, the Grand Council Chief, has said she has not been consulted. We have a number of others that are saying the same thing. First of all, did you have any involvement in the consultation? I believe some are saying they've been given 7 days notice on this. Were you involved in any of the consultation, especially with this nation? And is that the plan going forward, that 7 days notice is adequate consultation?
Thanks for the question. So the project was led by another department, and there was a number of organizations, not only Indigenous rights holders, but also national Indigenous organizations that were engaged on the legislation. Moving forward, the legislation has a two-part, I guess three-part, if a project was to be removed on the consultation. So listing a project in Schedule 1 involves consultation with impacted Indigenous rights holders. The second part, if a project would be
Maybe if I could just cut in there, because in your answer to Ms. Stubbs there, you talked about meaningful consultation. It has to be adequate, but there were no definitions to that. And we're seeing nations here say 7 days. Is that the definition of meaningful and adequate?
Yeah, so as I mentioned, the meaningful and adequate consultation is fact and situation specific. So some of the work that our department has been doing over the past year has been working with Indigenous rights holders as well as national organizations on developing protocol guidelines for the federal government. Outside of that, I do know First Nations, Inuit, Métis also have protocols and consultation guidelines, so we'd be looking to engage with the impacted Indigenous rights holders to make sure that we are...
So what about those that are in favor of projects? We have a number of Indigenous communities that are in favor.
Exactly. So when we're consulting on whether to include a project in Schedule 1, as well as the consultation once a project's added and the conditions, we'd be working with those Indigenous rights holders. And we have Indigenous proponents that want to bring forward projects under this bill.
Okay, so that's good if they want to bring that forward. But how do you still deal with the fact that C-69 is still in place? I know this bill gives extraordinary powers to the government, but at the same time, you still have some pretty powerful impediments to development in place right now.
A very
So-
short response, please, Minister.
Yeah. So the legislation for the One Economy is listing a project in Schedule 1 as well as putting the conditions. We engage with Indigenous rights holders, consultation and accommodation. So it would also, if we were removing a project, again, the consultation and accommodation would occur.
Thank you very much, Minister.